Agency relationships, the foundation of every transaction. As we continue building from supervision and operational control, we now move into one of the most critical areas of broker responsibility: agency. If Section 2 focused on how brokers supervise, this section focuses on what brokers are supervising when it comes to client relationships. Every transaction begins with agency, and every compliance issue often traces back to how that relationship was established, explained, and managed. Agency is not just a disclosure. It is a legal relationship that defines duties, responsibilities, and risk exposure. In Arizona, agency relationships must be clearly disclosed and consistently managed throughout the transaction. The failure to properly establish agency is one of the most common triggers for complaints, disputes, and litigation. At its core, agency answers one simple but powerful question: who do you represent, and what duties do you owe them? If that question is unclear, everything that follows, contracts, negotiations, disclosures, becomes vulnerable. Example: an agent begins showing homes to a buyer without presenting the real estate agency disclosure and election (READ) form. The buyer assumes representation, but no formal agency relationship exists. Later, a dispute arises over advice given during negotiations. Without proper agency disclosure, the broker may face liability for misrepresentation or failure to protect the client's interests. This is why agency must be addressed at the very beginning of the client relationship and reinforced throughout the transaction. ARS, paragraph 32-2153A, 2, misrepresentation and agency risk. ARS, paragraph 32-2153A, 2, addresses misrepresentation and false promises, which are often directly tied to agency relationships. When an agent fails to properly define who they represent, it creates confusion that can easily lead to misleading statements or actions. In 2026, ADRI continues to enforce the statute aggressively, especially in situations where buyers or sellers claim they were misled about representation. The key issue is not always intentional misconduct. It is often a failure to clearly communicate the scope of the relationship. Example: an agent provides advice to an unrepresented buyer that appears to favor the seller's position. The buyer later claims the agent was acting in their best interest. Without proper disclosure and documentation, this situation may be interpreted as misrepresentation under ARS, paragraph 32-2153A, 2. Case law connection. In Lombardo v. Albu, the court reinforced that material information affecting a party's decision must be disclosed, even when agency relationships create tension between duties. This highlights the importance of clarity. Agents cannot hide behind confusion when agency is not properly defined. The takeaway is simple: unclear agency creates liability. AAC R4 281100 F. Duty to disclose and protect the public. AAC R4 281101 F. Requires licensees to disclose information in a manner that is truthful, accurate, and not misleading. This rule directly ties into agency because the duties owed to clients and non-clients depend on the relationship established. Even when an agent does not represent a party, they still owe a duty of honesty and fairness. This is where many agents and brokers get into trouble. They assume that no agency means no responsibility, which is incorrect. Example: a listing agent knows of a material defect, but assumes they only owe duties to the seller. Failure to disclose that defect to a buyer may violate both R4 281101 F and case law such as Hill v. Jones, 1986, which established the obligation to disclose material facts that are not readily observable. Agency defines who you advocate for, but it does not eliminate your obligation to act honestly with all parties. How agency must be built into your policy manual. Your broker policy manual must clearly define how agency relationships are established, documented, and managed within your brokerage. This includes when disclosures are made, how they are explained, and how they are documented in the transaction file. In 2026, best practices include requiring agency disclosure prior to any substantive discussion, consistent use of updated ADRI AAR forms, and documentation of all agency elections within the file. Example: a brokerage policy may require that the READ form is presented and signed before showing property. This creates a clear record of agency and eliminates confusion later in the transaction. Additionally, policies should address dual agency, limited representation, and situations involving teams, ensuring that agents understand how to navigate these relationships without creating conflicts or violations. Additional comment: the real risk of agency in 2026. The biggest risk in agency today is not lack of knowledge, it is inconsistency. Agents may understand agency in theory, but fail to apply it consistently in practice. This is where brokers must step in with clear policies, training, and enforcement. AgeRay is increasingly focused on whether brokers have systems in place to ensure proper agency disclosure and management. If multiple complaints arise from agency confusion, the broker's supervision system will be scrutinized under AAC R4 28-1103. Another emerging issue in 2026 is the use of teams and AI-driven communication. As highlighted in Substantive Policy Statement 2025.03, teams operate under the broker's supervision and must clearly represent the brokerage in all interactions. Example: a team member communicates with a buyer through automated messages that imply representation without formal disclosure. This creates agency confusion and potential liability for the broker. The solution is clear. Agency must be intentional, documented, and consistently reinforced across every interaction. How this section connects forward agency is the starting point of every transaction, and it directly impacts everything that follows: contracts, disclosures, negotiations, and closing. In the next section, we will build on this by exploring how agency connects to transaction management and documentation, ensuring that what is established at the beginning of the relationship is properly carried through to the end. Online discussion. Why is agency considered one of the highest risk areas for brokers in Arizona? Answer: because it defines duties, responsibilities, and expectations. If agency is unclear or improperly disclosed, it can lead to misrepresentation, disputes, and violations under ARS, paragraph 32-2153. How does ARS, paragraph 32-2153A2 relate to agency relationships? Answer: it addresses misrepresentation, which often occurs when agency is not clearly defined. Confusion about representation can lead to misleading statements or actions. Why must agents still act honestly with parties they do not represent? Answer: because AAC R4 28-1101F requires truthful and accurate communication with all parties, regardless of agency.